they can be very dangerous to believe because either the information is incorrect or it doesn't apply to your situation, or there are better ways to handle things, or the person relaying the information doesn't understand the topic themselves. So there's a lot of these things that we often hear that we want to make sure that we educate people on when we can, because the misinformation out there is really one of the most dangerous things when it comes to somebody's estate. Not necessarily, what the experts are telling people or what good sources are telling people, but sort of that misinformation that gets really relayed through various sources. So we have a couple topics to talk about today, things that you might have heard. But it is our second to last webinar for the year. So next week, we are actually going to be covering our very popular wills versus trust topic and kind of what the difference between those two things are. Well, welcome everybody. I'm attorney Justin Randall with Hooper Law Office. Our topic today is the common estate planning myths that we often either hear people come in with when they come and meet with us, or what the internet might say, or what possibly even some of those quote unquote experts on national television that sell products, things like that are either incorrect or just don't necessarily apply to most people's situation. So a couple things before we get too in depth on that topic. If you registered for this, you will be receiving some materials from us afterwards. It is the main one, information-wise, is, probably can't quite see it from here, but our top estate planning myths and kind of what the myth is and what the actual what the reality is behind that myth. And then you will also be receiving a feedback form from us. That feedback form is a place where you fill out, or you can fill out, how you think this went, or if there's any topics that you're interested in that you'd like us to go more in depth on. Any feedback is helpful. Obviously this is our first year doing it this way, so it's always good to get some, constructive feedback there. And also, if anything I talked about today or just anything in general leads you to want to come in and talk to one of our attorneys, there is a place for you to fill out that you would like us to reach out to you. And once you submit that, we will reach out to you and set up an initial consultation. Our initial consultations are usually scheduled for around 2 hours. They may go longer, may go shorter, kind of depends. But they are free of charge, so they don't cost you anything to come in and talk to us. We can't really accurately know what you need until we sit down and talk with you. So it's really important that no one's afraid to do that. But why don't we get started? So as I mentioned, there's a lot of estate planning myths out there that is really just either coming from bad sources or people who don't really understand what they're talking about. Or may have heard it and honestly believe that it's true, but it's just not quite accurate. We have them listed on this material that you'll be receiving from us. And this is not an exhaustive list by any means. It's kind of the top ones we tend to hear. But really, the biggest myth I think that people come in with is that it's the size of someone's estate that really is what dictates what type of plan they need, or what type of documents they need to use, or how important it is to plan at all. And that's really just not the case. I mean, it is a factor in someone's plan. I mean, obviously you might do different planning for somebody who has, $100 million and has estate tax concerns versus somebody who may have $1 million estate and, isn't above that estate tax limit. And just has other sort of goals that they're trying to accomplish. So it's a factor in it, but it is not the most important factor. Really, the most important factor in your estate plan is really you, your family, what your personal situations are, and what your goals for that estate plan are. For example, if you did not want anything to go through probate, you really didn't want, you had a bad experience with your parents' estate, or you just heard bad things, and you really don't want your family to have to go through the probate process, one of the most important things to know is that, well, then a will is probably not the right plan to use going forward, because wills only direct assets that are going through the probate process. So it's really not, that's a good example of where it's not the size of the estate that matters, but in this example, somebody's goal is, hey, I really don't want to use this process. So, what's the right plan for me? Well, if that's your goal is to avoid probate, well, then a will is not the right tool because it just doesn't help you outside of the probate process. That's where it controls and directs those assets. So yeah, money is a factor, not the most important factor by any means. So speaking of wills, another common mistake or example of a myth that we hear is that estates can avoid probate with a pour-over will. So what a pour-over will is when somebody, for example, has usually a revocable living trust, they'll have a will as well, and that will is what we call a pour-over will. Essentially, what it says is, hey, if anything isn't owned properly by my trust when I pass away, or isn't beneficiary designated to my trust when I pass away, and has to go through probate, well, my pour-over will directs it back to my trust. It's kind of pours everything back over is the way I tend to think about it. So the big myth here, though, is that, oh, if you have a pour-over will, you're never going to have to use probate. Well, as I mentioned earlier, though, a will only directs assets that are going through probate, and that includes a pour-over will. What a pour-over will is an essential document to still use when you have a trust to make sure that if something goes completely, not according to plan and does end up going through probate, that you get it back to the right, right place. But that, a pour-over will still only directs those assets that are going through probate. It doesn't, if you just have something, with a beneficiary designation that's completely different than what your trust says, well, that's what's going to still control, because that is the first place that someone's going to look when they, dole out that account or pay out that account, however it was set up. And and I forgot to mention this earlier, but if anybody has any questions and you are participating via Zoom, we do have a question and answer function. So if anything raises any questions for you, please feel free to submit them. I'll answer them as they come up. It's helpful for me to know kind of what you guys want to hear about too. So yeah, please, if you have any questions, submit them, and I can see them right in front of me. So I'll get to them when they come up. So yeah, pour-over wills only control the assets that are still in probate. They do not direct assets outside of probate. There are other documents you can use to accomplish that goal, but you want to still make sure you're using that the proper documentation for that and the proper types of documents. You don't want to go forward thinking, I don't have to fund my revocable trust because I have a pour-over will and everything's going to avoid probate anyway. That would be a mistake, and it's a costly mistake too. For a number of reasons. One, it can be more expensive to go through probate, but also if you have very specific provisions in your will or in your trust, and those assets don't get back to the right place, well, then you spent all that money setting up a well-drafted trust, and it didn't end up doing anything for you. Those provisions didn't get followed. So, it would be a mistake to think that you're covered just because you have it and that you won't go through probate. It's still very important to make sure, especially with a trust, that you have things funded properly to that trust. Okay. Another really, really common thing that we hear from people, especially when they're concerned about, long-term care expenses, going to a nursing home, going to assisted living, things like that, is that, well, all right, most people are familiar with that 5-year look back period, meaning if I gave assets to anybody, transferred something to them, set up an irrevocable trust, anything like that, that if I needed to apply for Medicaid within the next 5 years, they would be able to see those transfers and hold them against me and give me a penalty. So most people are sort of familiar with that 5-year look back rule, but people think that, well, okay, as long as I do this more than 5 years in advance, I'll just still give the important assets to my kids during my lifetime, well in advance of ever needing care, so that I, make it out that 5 years, but it's also, then safe from nursing home expenses. And it's true that, yes, you could make it out the 5 years, and once those 5 years are over, you don't have to report those gifts to Medicaid anymore. But there are way better ways to protect those assets from long-term care than by giving them to your children. The big thing asset-wise that people tend to do this with is either their home or like a family cottage or something like that. Usually it's real estate that we're talking about in this specific example, but it can be anything. And the reason that can be very dangerous is not because you're necessarily your kids are untrustworthy, but one of the big things is you want to talk about losing control over something. Giving it to someone else so that they are the owner is the biggest way you can lose control. Hopefully your kids would never do this, but in theory, somebody could, evict their own parent or start charging them rent because now they're the owner of that home and they're allowed, legally speaking, those are things they're allowed to do. They wouldn't be very good children if that's what they're doing, and they're certainly not going to get anything nice for Christmas if that's what they're doing. But it's a horrible thing that can happen. Another thing too, outside of that, is it's really bad tax planning. So when, if I owned a home and I passed away and through my estate plan, whether that was a will or a trust, gave that home to my children, then they would not, what the IRS calls the cost basis of the home, essentially thinking about that as what I paid for it, that gets adjusted to fair market value when I die. So if it passes through my estate plan to my children, the IRS looks at that as if they bought the home for whatever the fair market value was when I died. Then if they turned around and sold it, there would be no capital gains tax, or very little anyway, that they would have to pay, depending on how long they held on to that home. But when you gift a property over to somebody, it doesn't get that step up in basis. Instead, what happens is it looks like to the IRS that my children paid whatever I did for it when I bought it. So if I bought my home in 1960 for $50,000 and today it's worth $250,000, if I gift that home over to them, and then they turn around and sell it, well, there's a huge gain on that. And when you are not the primary resident of a home, and it's not, or I should say when it's not your primary residence, and you turn around and sell real estate, you have capital gains to pay if there's a gain. And because it did not receive that step up in basis, there's a huge taxable gain that they have to pay. There are much better ways to protect real estate from long-term care where you get the best of both worlds there. You get that protection, as long as the 5 years are still made, and you get that step up in basis. But you have to know that you're doing it the right way. You don't want to just do this thinking that you're doing the right thing and then having an issue. The last thing with the home that I'll mention too is it does not account for things that could otherwise go wrong when you gift it just directly to your children. So what I mean by that is, a good estate plan, a good will, or a good trust will say things like, if one of my beneficiaries has some sort of special circumstance that I didn't foresee, like they developed a substance abuse issue or had creditor problems that they didn't when I drafted the document, or we're in the middle of a divorce, anything, that kind of life events that can happen, right? A good estate plan has ways to deal with that, and it has backup provisions that account for those things going wrong and has ways to protect those beneficiaries. But when you just gift something over to somebody, you're not accounting for those. It's now just their property. If they get divorced or if they get sued or file for bankruptcy, then that's an asset they own, and it's available, potentially available anyway, for a lot of those things going wrong. And with substance abuse, it's just more a matter of you're giving an asset to somebody who is not, shouldn't have control over a large asset where they can use it to fuel their substance abuse issue. So, things can go wrong just by gifting it over to your kids. And if nothing else, it's just bad tax planning. Even if you have the most trustworthy kids in the world, there are still better ways to do it where you get the best of both worlds. So that is one of the most common things questions that I get in particular is, I've heard about gifting the home to my kids. Should I do it? No is generally the correct answer there. There's much better ways to deal with it. And you just have to talk to somebody that, practices in ideally both elder law and estate planning. And that's all they do, right? I wouldn't go to a neurosurgeon to do, like open heart surgery, right? So another really common myth here is people who have either beneficiaries with special needs, children with special needs, or family members or family friends with special needs, and they want to leave something to them. But the common advice they're given is, oh, well, don't give anything to them. Their benefits that they're receiving are means-based, which means if they get over a certain amount of assets, they're going to lose their benefits. So I shouldn't give anything to them. And it's coming from a good place usually. It's, that advice is true, that if you give something directly to that beneficiary and they are on any sort of means tested program, sort of like Medicaid, for example, or any other special needs based means tested program, those are means tested, meaning if you go above a certain asset in your own name, or asset limit in your own name, you have to be honest and report that to that program, and they'll cease the benefits until you get back down below that. But the solution to that is not necessarily, it does not have to be, oh, just don't leave anything to them because it's going to harm them. There are specific ways that you can have a beneficiary with special needs inherit assets where you utilize what's known as a supplemental or special needs trust. And as long as that is drafted properly and it is the assets that you're sending to them are properly designated, or and they end up in that supplemental needs trust, you can leave assets for the benefit of somebody with special needs without causing them any harm. That trust will have provisions in there that say it can't replace their benefits, so it has to be used for different things, but it can still be something that benefits them, things that their programs don't cover. For example, if someone's on Medicaid and they have a supplemental needs trust, it can't necessarily be used to pay for like a long-term care facility, but it can be used to pay for things that Medicaid isn't covering. So, what about their cable if they want to watch TV while they're in a long-term care facility, or their cell phone bill? I mean, that's just an example, but so you do not have to disinherit somebody just because they are a child with special needs. And I did see that somebody is raising their hand. So I'm unable to see the raised hand. If you have a question, if you want to try typing it into the question and answer section or Q&A box, it should pop up to me, or if you want to do possibly the chat box, I don't know if that'll show up. Otherwise, if for some reason I can't get to it, I don't see it pop up, if you want to email our learnmore@hooperlawoffice.com, I can try to get to it after the webinar is over, if nothing else. But otherwise, I should be able to see it in the Q&A box, but I just can't see the raised hand. So yeah, I'd be happy to answer your question now. Okay. And this is a myth that we deal with. This next myth is a myth that we deal with quite a bit, and that is that funding a trust is optional and that you don't really need to do it, or you don't need to follow the terms of your estate plan because that's what's going to control no matter what the specific accounts say. And unfortunately, that's a very dangerous myth to believe, because a trust, just like a will, only controls and only directs the assets that are actually sent through the probate process. A trust only controls the assets that it owns, whether during your life or at death. So that means, though, is that it's incredibly important to make sure that you do what we call trust funding. And by that, I mean either titling the assets in the name of the trust if it's something that can be owned by the trust or you want owned by the trust, or at least utilizing at the very least beneficiary designations on the account. And what I mean by that are like payable on death or transfer on death designations to get them to the trust after you've passed away. Without doing that, the terminology, the provisions you put in the trust, or how you want things to go after you're gone, or taking care of you if you have an incapacity, those types of things are not going to apply to assets that are not properly funded. Same way that a will only controls what's going through probate, a trust only controls what it owns. So it is not an optional step if you want your plan to work. And for example, we at our firm, we do that trust funding for our clients because it's so important, and because, quite frankly, people don't like to do it. It is a hassle. So what we found is the most successful to make the plans work is we do it for our clients. But it is definitely not an optional process if you want your plan to work. And the same thing can be said about a will, right? If you are intending to use your will, it doesn't mean you necessarily have to send absolutely everything through probate, but it is important to send some money through probate for your executor or your personal representative, because they, as part of probate, have to make notice to creditors and have to pay off final expenses and all of that. And they're the ones who sort of have to coordinate that. So what that means, though, is that if you don't leave any money that, to go through probate at all, that personal representative may not have any funds to pay off those creditors. Even if your estate size was large enough to completely pay off those creditors, if you left it directly to the beneficiaries, they're under no obligation to give it back to that personal representative to fairly pay for the expenses. So, I could say I want all of my kids to inherit equally, and one of the children is the personal representative, and that personal representative may choose to use some of their inheritance for the expenses. But then, if I had 4 kids, the other 3 are not responsible for paying them back. And so if you really wanted it to be equal, what you really want is you want the expenses to be paid by the estate before any distributions get made out, so that it actually ends up being the way you wanted it broken down. And it's a lot of stress to be put on a personal representative if you are naming them in that role and are not giving them the resources that they need to properly administer the estate. So, if you have a will and that's what your intended plan is, you want to use the right path going forward, and you want to have the proper designations on there, at least some money going to the estate. The next myth here is another common one with long-term care. You may be familiar with the gift tax exclusion, the annual gift tax exclusion. Currently $15,000 per person per year. So what that essentially means is you, and if you're married, your spouse can each give away $15,000 to everybody you know, and not have to file a gift tax return. Unfortunately, though, just because the IRS says you can do something without having to file a gift tax return does not mean you can do it for long-term care purposes. So all of that means when you file a gift tax return isn't that you actually necessarily have to pay taxes on it right then. It's that your end of life estate tax exclusion gets lowered by the amount that you went over. So for everyone listening to this right now in Wisconsin, you have currently, I think it's going up to $11.7 million per person, for you and your spouse each, that you're allowed to give after you pass away. So you and your spouse would have to have over, $23 million before you even have a concern for that. But just because you're meeting, or going under that limit for estate tax purposes and for gift tax purposes does not mean that Medicaid thinks that's okay. The amount you're allowed to give away for, Medicaid purposes, even within that 5-year look back period, is $0. In theory anyway, it's $0. You're not allowed to give any money away without paying for something in return, a good or a service in return. You will have to report that to Medicaid on a Medicaid application, and it can cause a divestment penalty for somebody. The biggest concern there, though, is not that if you accidentally did it. I mean, it would cause a penalty, but if it was a one-time accident, that's a little different. It's the people who do this thinking it's a strategy to protect things that are really going to be hurt by this, because they may have given all that money away thinking they were doing the right thing, and maybe giving it to their kids, and maybe their kids spent it, right? Those kids may not be able to give that money back. And with Medicaid in Wisconsin, in order to get rid of a penalty that you created, you have to fully receive back what you gifted away, which can be very difficult to do. There's no partial cures in Wisconsin. Another myth that we run into quite a bit, and I've kind of talked about this a little bit already, but that trusts are only for wealthy people. And it's similar to the first myth of your estate plan is so dependent on how much money you have. And again, that's just not really true. If you really don't want your assets to go through probate, but you still want the same sort of central planning that a will can provide, a trust is a good option for you. I mean, trusts are very useful tools for a lot of people, and they don't necessarily need to be multimillionaires or billionaires or even having $1 million. I mean, you can be, well below that and it still be a worthwhile tool for you. What type of document you use for your estate plan, whether it's a will or a trust, is a lot more dependent on what process you plan to use after you've passed, or you want your estate to use after you've passed, I should say. So, the benefit of a trust over a will, if your goal is to avoid probate, is that trusts are not subject to probate. They are administered. Sometimes it's kind of jokingly referred to as like kitchen table probate, because you're not doing it in a courtroom. You're not doing it through the court at all. You're just managing it at home or through a law office. I mean, that's a huge benefit of it. So it's less about how much money you have and what do you intend to use for your estate. If somebody had $100,000 and just said, I really don't want to go through probate, well, then I would have to tell them, a will is probably not the best tool for you if you have any sort of specific wishes here. So it's really more dependent on what you want to do with your estate after you're gone, and way less dependent on how much money someone has. As I mentioned, money obviously can play a factor in what, specific planning you do, what type of trust someone uses, but that is by no means the most important factor. Another unfortunate thing that comes up a lot is somebody thinks that all trusts are identical, right? Well, I put my home and all of my assets into my revocable trust. So what do you mean you're telling me that I still have to pay, those are still available for long-term care expenses, and that I still have to report those to Medicaid? So revocable trusts, revocable living trusts, where you can revoke them at any point, you can amend them freely. There's not as many restrictions on them as like an irrevocable trust, for example. Those are not protected from long-term care expenses. They, prior to 2014, if they were set up prior to 2014, were, I should say, protected from estate recovery, where Medicaid can come back against the estate and kind of say, well, we paid this amount of money, pay us back. Those used to be protected from that aspect of it, but it was always available still for their care during their lifetime. So it is not a safe asset if it is within a revocable living trust for long-term care purposes. So if you have long-term care concerns and you want to protect something from long-term care, there are other planning mechanisms that you can use to do so and actually get that protection that you're looking for. You don't want to go into this thinking I'm fully covered, I have a revocable living trust, I'll never have to spend this on my long-term care. That's a very costly mistake. And then another, this may be less kind of generalized advice, but for anybody who does have estate tax concerns, as I mentioned, it's not as many people as it used to be in like the 1990s, because again, you have to, per person, have to have over $11.7 million going into 2021. A mistake though is thinking that life insurance proceeds are exempt from that, and that you never have to spend or pay any estate taxes on life insurance proceeds. And unfortunately, that's not true. So life insurance proceeds are tax-free in terms of general income tax to the recipient of those proceeds, but they are still included in the size and the calculation of the estate. So it can still bump you over, if say you had $11.4 million and then you had a $400,000 life insurance policy, that still bumps you over that exclusion amount. So you would still have some estate taxes to pay on the estate. Maybe not directly out of those life insurance proceeds, but something in the estate would have to pay it. So it's just, it's not estate tax exempt. It can still bump you over that amount. It's just important to know that if you do have those concerns, although, I believe, I don't have the updated statistics on this, but I believe last I saw, it's like less than, 0.1% of America something like that has, a taxable estate. So it's not going to be the widespread advice for a lot of people listening to this. It's certainly not for me. So, just it's advice to heed, though, if they ever lower that estate tax amount again, which there are some talks of that happening, down to last I saw, the talk is somewhere around 3.5 million. But again, it's completely dependent on what laws actually pass, right? So with that, we're getting close to time here, but I want to thank you all for joining me again. And we do have one more webinar coming up this year. It is on the 16th, I believe. Yeah, whatever next Wednesday is, if that's the 16th, then that is our wills versus trust. So I went into it a little bit today. We talked about kind of the difference between a will and a trust, but we'll go more into it next week as well. So if you have any interests in that topic and you're looking at getting something set up for yourself, it's going to be a really good one to check out. But otherwise, please send in those feedback forms. They are very helpful to us. But thank you all for joining, and I will see you next week.